Calculating damages. In the previous podcast, I talked about breach of contract and the notion of anticipatory breach, a warning or behaviour by a party to a contract that they are not going to perform their obligations. In this podcast, I will talk through the framework for the calculation of damages for breach of contract, starting with the general principle, and then looking at calculation of quantum of damages, including the position on claiming damages for distress or loss of enjoyment. I will then talk through the requirement of something called remoteness, and how closely connected the damage must be to the breach, and I will conclude by talking about the requirement of mitigation of loss. The general principle is that damages should put the innocent party into the position in which they would have been had the contract been properly performed. See the case of Robinson and Harmon. In other words, the claimant should get as damages what they have lost as a result of the breach. Unless circumstances are exceptional, account for profits is not available as a remedy. Account for profits is the situation in which a profit made by the defendant because of the breach is paid to the claimant, rather than the claimant being paid damages to put them in the position they would have been in if the contract had been properly performed. These are available, account for profits rather, are available in exceptional circumstances only, according to the quite famous Spycatcher case, Attorney General and Blake. When assessing the quantum of damages then, you're looking to determine what it would take, how much, to put the innocent party into the position they would have been in had the contract been properly performed. It is a matter of the court, although of course both parties are likely to have a view as to what that should be. In some cases, it is simply not possible to put the parties in that position because it is not possible to calculate the damages. In the case of Morrow, for example, the claimant had fitted out a ship to undertake some salvage work and travelled to the area of the supposed wreck to recover it, having won a tender, had a contract, to do so. They were not able to recover the ship, and it turned out that there was no ship to recover. An attempt to put them back in the position that they would have been in had the contract been properly performed would have required the court to work out how much profit they would have made from the salvage of a non-existent ship. As this was not possible, the court instead awarded the claimants their costs for the wasted expedition. They were probably not left much out of pocket, but they were certainly not in the position they would have been in if the contract had been properly performed. Conversely, consider the case of Chaplin and Hicks, in which the Court of Appeal awarded damages to someone who was contractually entitled to an audition, but who was notified too late to enable her to attend. Although there was no guarantee that she would have won a role, there were more people auditioning than there were roles, the court felt that the right to the audition was in itself something of value, and that was remediable in money. Now, one would need to prove that there was a real and measurable chance that they would have succeeded in the audition to get an award of damages. Moving on from sort of loss of opportunity, one might also look at the distinction between damages in the sum of the cost to fix a breach and the sum of the difference between the value of the item had the contract been performed properly and the value after the breach. Where the cost to repair, to replace the item with one which meets the contractual requirements, is much greater than the difference in value, a court may be inclined to hold that the reasonable measure of damages is just the difference in value. Do take a look at the Ruxley Electronics and Forsyth case. The case dealt with a swimming pool which was constructed in someone's garden, and the pool was slightly shallower, a matter of inches shallower than the specification required. To fix it would have been very expensive. The original work would need to have been undone and completely repeated. Whereas the difference in value between the pool as it was and the pool if it were a few inches deeper was much, much smaller. The court felt that the appropriate award was the difference in value, not the cost to undo all the work and rebuild the swimming pool to the correct depth. Moving on from physical loss or economic loss, The traditional rule is that damages are not available for mental distress alone, but instead must be linked to economic loss. This position has gradually changed, however, and damages for mental distress are now recoverable in some circumstances. In the case of Jarvis and Swan Tours, the claimant booked a holiday from the defendants, who had made a number of promises about the attractions on offer. The holiday failed to live up to the promises. If you read the case, you'll see just how disappointing the holiday must have been, and the claimant sued for damages. At first instance, he was awarded a relatively modest sum, just representing the money he had paid for the holiday. He appealed on this point, and Lord Denning, then Master of the Rolls, ruled that a contract which exists to provide entertainment and enjoyment was a sound basis on which claim for damages for distress could be founded, and the Court of Appeal increased the award by a significant sum for the loss of enjoyment. The case of Watts and Morrow in 1991 clarifies the scope of this exception to the general rule that damages are not recoverable for mental distress. The case dealt with a negligently performed survey for a house, and the claimant sought damages for the mental distress associated with the necessary remediation work on the house which they had bought in reliance on the surveyor's report. And Lord Justice Bingham held that damages for non-economic loss are only recoverable where the very object of the contract is enjoyment or pleasure, and the claimant suffers physical inconvenience too. Not all damages which a claimant might seek are recoverable at law. Where there is an insufficient link between the damages sought and the breach of contract, recovery will not be granted, and that lack of sufficient link is known as remoteness, and the key case is that of Hadley and Baxendale from 1854. The case relates to a contract to deliver a mill shaft. The claimants in the case ran a mill, and their mill shaft, an essential component of the infrastructure, broke. They did not have a spare one, not good business resiliency planning, and contracted with the defendant to take the broken shaft to a repairer to use as a model for a new shaft. The defendants promised to deliver the shaft within a day, but did not do so. It arrived a week late. The claimants, who were not able to operate their mill for that period, claimed for loss of profits, that the delivery company should be responsible for the money which the mill would have made if the defendants had delivered the mill shaft on time. And the court held that no, loss of profits were not recoverable, and the damages could only be recoverable where they were either A, naturally arising from the breach, and also as may reasonably be supposed to have been in the contemplation of the parties at the time the contract made as the probable result of the breach of it. As the loss of profits were not naturally arising from the breach, as the claimants could, and probably should, have had a spare mill shaft, nor were they in the contemplation of the parties at the time of the contract, the claim failed. The bar for finding that something may reasonably be supposed to have been in the contemplation of the parties is a very low threshold. The House of Lords ruled in the Heron 2 that the test is merely that the outcome in question was not unlikely. For a loss to be recoverable as being one which may reasonably to have been supposed in the contemplation of the parties, the contemplation need relate only to the type of loss rather than the extent of loss. Thus, as long as the loss which happens is the same type of loss as the one which may reasonably supposed to have been in the contemplation of the parties, a difference in the quantum, the extent of the loss, if it is higher, for example, will not prevent recovery. Unfortunately, the case law is not very clear exactly on what is meant by type of loss, which makes this somewhat unclear in practice. The case that's often cited on this point is Parsons and Uttley Ingham, in which the claimant pig farmers bought a feeding system from the defendants. The defendants were negligent in their installation of the system, with the result that the claimant's pigs ate food which had gone mouldy. The pigs died. The Court of Appeal held that, even if the parties might not have appreciated that the pigs might die, It would have been in their reasonable contemplation that getting the system wrong would cause physical harm to the pigs, and death was of the same type, and so capable of recovery. I'm not sure that this is particularly helpful, and it would be useful for a Supreme Court ruling to clarify exactly what is meant by this. In practice, it likely means that a claimant would want to argue that whatever loss they suffered was of the type that the parties would have contemplated, and the defendants will try to argue that it is entirely unrelated. The final limitation on recoverability of damages is the obligation on the claimant to mitigate their losses. They must take all reasonable steps to lessen the loss which they suffer. Neglecting to do this is a choice that the claimant can make, but it will prevent recovery of those damages, British Westinghouse Electric and Underground Electric Railways. And the case also establishes the principle that the requirement is only to act reasonably. It does not require a claimant to take steps which a reasonable and prudent man would not ordinarily make in the course of his business.